The Illinois State Constitution. Illinoisans, we the people, have a happy Thanksgiving. Article 3, Suffrage and Elections. In addition to setting voting qualifications, this article establishes a state board of elections to act as a central coordinating authority for all the state's election districts. The last section provides for all the general elections except local ones to take place at the same time as elections for the General Assembly. To increase voter turnout. Section 1. Voting qualifications. Every United States citizen who has attained the age of 18 or any other voting age required by the United States for voting in state elections and who has been a permanent resident of this state for at least 30 days next preceding any election shall have the right to vote at such election. The General Assembly, by law, may establish registration requirements and require permanent residence in an election district not to exceed 30 days prior to an election. The General Assembly, by law, may establish shorter residency requirements for voting for President and Vice President of the United States. This section establishes 3 basic requirements for voting eligibility: U.S. citizenship, age, and duration of residence in the state. The General Assembly may also set registration requirements. The 1970 Constitutional Convention submitted to the voters as a separate question the issue of lowering the minimum voting age to 18 years. That proposition was defeated, and this section, as approved by the voters, set the voting age at 21 or any other voting age required by the United States for voting in state elections. But after the 1970 Constitution was adopted, an amendment to the U.S. Constitution was ratified by the states, including Illinois, setting a nationwide minimum voting age of 18. In 1988, Illinois voters approved an amendment to this section, reducing its state minimum voting age to 18. This section was ratified in 1970, set a minimum state residency requirement of 6 months for voting. However, the U.S. Supreme Court held that state residency requirements of more than 50 days for voting imposed too heavy a burden on the constitutional rights to vote and to travel between states, and thus are invalid. The 1988 amendment to this section also shortened the minimum state residency requirement to 30 days. The section of the Election Code setting requirements for voting also allows a person to vote after 30 days residence in state and elected district. The Illinois Supreme Court in 1996 held that the law abolishing the terms of persons already elected at University of Illinois trustees and allowing them to be replaced by gubernatorial appointees violated the right to vote by nulling all votes that had been cast for the existing trustees. But the court said that the method of selection of future trustees could be statutorily changed from election to appointment, as has been done. Although not mentioned in this section or its predecessors, lack of sound mind has been held to disqualify a person from voting. And the committee that proposed this section at the 1970 convention intended no change in that rule. Section 2, voting disqualification. A person convicted of a felony or otherwise under sentence in a correctional institution or jail shall lose the right to vote. Yes, my ex, Shane Tyler Propert Sr., all of him, should not be able to vote. Ponder that one, we the people. Which shall be restored not later than upon completion of their sentence. Which says, after you finished your sentence, as a felon, you can vote again. You really need to ponder that one out. A law enacted under the 1870 Constitution formally provided that a person sentenced to prison could not resume voting without first obtaining a certification of restoration of the rights of citizenship. That sounds a little bit more logical. A law enacted under the 1870 Constitution formally provided that a person sentenced to prison could not resume voting without obtaining First, a certificate of restoration of rights of citizenship issued by the governor or a court. Amendments since then have changed the provision to say that no person who has been convicted in any federal or state court of any crime and sentenced to confinement in any penal institution may vote until his release from confinement, apparently implying that restoration of the rights to vote occurs automatically at that time. Citizenship takes good, lawful behavior, not just the appearance of being good and lawful. No, you can't just strip people of their rights, but if they're convicted of a felony, and that takes a lot to convict someone of a felony, trust me, I went through it about 20 years ago. It's a big ordeal for the whole people, like nation, state, states, and yes, the family involved in all of that. It's not an easy thing. Having been married to a criminal. The term penal institution in that statute apparently includes a jail, consistent with the wording of this section. The statute treats a person who is on furlough or work release from prison as confined, but not one who has been released on parole. May God, above all the nation and the states, yes, and who helped establish your constitutions of your state and your federation, yes, we the people, help us all understand this and apply it rightly to ourselves and our lives. Peace, domestic tranquility. Godspeed.